we proceed discussing the problem of IHL and international human rights law. And now the floor is given to Adenif for presentation for your report. Adi, the floor is yours.
Thank you very much for the introduction and for the invitation. Just a preliminary comment. While I used to work at the UN and of course Eurojust, I do not represent any organization, and only I can be blamed for what I'm going to say today. I would like to dedicate the next 20 minutes or so to discuss the dynamics or the tension between IHL and human rights law. Most of the members of the colleagues already touched upon the topic, but try to speak a bit more from, or try to bridge it to the battlefield, to the war zone. How actually this friction, or sometimes there's a friction between two regimes, actually translate in practice. And as I've been told today, and I thank my colleagues to the panel that actually going to make my life a bit easier, so I don't have to delve into all the specificities of the relationship between IHL and human rights law. I'll just say some preliminary comments about that. First of all, it's not surprising that there's an overlap between IHL and human rights law. IHL touches upon many aspects that are traditionally falls within the realms of human rights norms. I spoke about due process, detention, issue of Common Article 3, and of course, we can also see other articles more straightforward. Article 52 of the First Geneva Convention, speaking about the guarantees for the protection of workers. Article 75, one mentioned from the additional Protocol 1, speaking about the fundamental guarantees that are provided in times of war, international armed conflict. And interesting, Article 72 actually recognizes that the applicability of Article 75 is in addition to any other rules of international law that protects fundamental human rights that are in armed conflict. On the other end of the spectrum, from human rights perspective, as you already mentioned, ICCPR, European Convention of Human Rights, they recognize that in case of state emergency, when there's a threat to the life of the nation, that you may derogate from some of the rights. So that is, of course, there is some kind of relationship that is built in and the recognition of one regime of the existence of the other. Now, they touch upon the topic of the applicability of both at the same time. Now, of course, there's a bit of a difference in the sense that IHL apply normally in a different time zone, only in the times of war, whereas traditionally human rights law applies in times of peace, but actually we accept today that it applies throughout the year. Maybe the geography of the two regimes don't always coincide, and I'll touch upon in a second. But there is, the topic I want to discuss, of course, is when they both actually operates at the same space and the same time. And from that point, it's not always straightforward. And Dick mentioned that as well, it's not always straightforward to know when, in which situation actually both a regime applies, when human rights law actually applies in terms of armed conflict. And we mentioned, of course, the ICCPR, that according to the ICJ and other institutions, applies also beyond the borders of a state under the condition that it falls under jurisdiction, the person or the area falls under jurisdiction of the member state. However, not all states accept that. The US have some concerns about Israel, possibly also the UK and the Netherlands, and they might be even considered, or some of them consider themselves as persistent objector, and I'll touch upon that in a second. But let's presume that actually human rights norms apply beyond the borders in that specific context. But when? If you follow, for example, the European Court of Human Rights, that applies when the state has an overall effective control over the person or the area. So we're speaking about detention, we're speaking about belligerent occupation. However, and it was mentioned the case earlier by Dick, that in the case where NATO bombarded radio station in Serbia during the conflict in former Yugoslavia, the European Court of Human Rights did not see it as creating enough jurisdictional links between the incident and the state conducting the attack, and therefore the convention was not applicable in that case. However, in contrast to that, if you look at the decision of the Inter-American Commission on Human Rights with regard to the case where Cuban airplanes shot down a plane belonging to an association called Brother to the Rescue, they found that in that scenario, the airplane of the association was technically under the control and authority of the MiGs from Cuba, and therefore the commission had the mandate, had the competence to discuss the case. And of course, I'm simplifying, I'm making contradiction between two different institutions that interpret two different regional conventions or covenants, but just to exemplify that it is not always that clear, and it's getting even more complicated when we speak about non-international conflict. So, presuming for a second that this is not a problem, that both IHL and human rights apply the same time zone, the same geographical scope. As was mentioned, there's two approaches basically in that kind of scenario. One is basically saying if the norms coincide with each other, it's an issue of complementarity, of mutual reinforcement between one and the other, and you can derive, for example, use standards from human rights in the situation within the paradigm of IHL. When it doesn't coincide, when it's some kind of sort of friction, and one example was mentioned by Marco Sassoli, then you have the issue of lex specialis. And I must admit, I agree that I have a difficulty to accept that the lex specialis is basically saying that the more specific law is the one that prevails, that it applies to a branch of law as such. I think it is important to check every norm and norm to see which one is better tailored to the situation at hand. And of course, it only makes sense that when we speak about armed conflict, it won't be surprising or shocking that in most cases, the norms of IHL, who are tailored for this kind of situation, will prevail because they're better tailored, they're more specific, and they're all the one to be used. But let's use, and this is what I wanted to do, is actually to use a specific example, a scenario in which there's kind of not a conflict, but a friction between the two paradigms. And the example I want to use is a scenario when you have armed conflict between state A and state B, and seemingly civilians or a mob from state B, counting by hundreds or thousands, come to the border in order to have a protest, but also to breach the border between state A and state B. Now, if you look at it purely from IHL perspective, you would say, well, there's a conflict between state A and state B. It's an international conflict. You have a group of people who try to penetrate, possibly as part of the conflict, to penetrate through the border. That threatened the integrity of the territory of state A. And some might want to argue that in that case, that should IHL apply. However, this is not that simple, not at all. Because from the other perspective is that riots or demonstrations are normally fall classically within the regime of law enforcement paradigm. And therefore, that should apply. Now, the consequence of that, and this is critical for the soldier at the border, because there's a huge difference of what he can and cannot do in those scenarios. If we're speaking about human rights law paradigm, then you have completely different principle of proportionality and necessity, who had nothing to do with the same principles in IHL, which means that he can only use lethal force if there is an imminent danger to his life or threat to his bodily integrity. Only if it's a serious danger for him or the people he needs to protect, other civilians, only then he can use. That is the principle of proportionality, a proportion between the use of force and the danger you try to avoid or prevent. On the other hand, in addition to that, you have the principle of necessity, which requires that he actually exhausted all other means that are non-lethal before using a lethal force. That's the issue of necessity, is you only use lethal force under the human rights paradigm as a last resort. However, if we're speaking about if from perspective of IHL you consider them the people who try to breach in, remove the mines of the border, try to breach the border as a combatant or civilian participating directly in the hostilities, DPH, then you don't need to take this into account. The principle of proportionality basically says you can target that person and you have taken into account the collateral damage. So you don't factor the life of the person that military target because him you can kill immediately. You don't need to go through all the process of exhausting other venues and other possibilities and tools at your disposal. So this is basically the scenario I'm trying to describe. And the reason I'm speaking about that is because actually there's an interesting case law from the Supreme Court of Israel discussing those issues. Israel had to deal with this kind of situation several times, once from the Lebanese border, Syrian border, but most recently with the border with Gaza. And there was a judgment rendered on that topic because there was a petition actually 2 petitions, regarding the rules of engagement of the IDF in that context. So I'm going to describe the facts of the case as they were mentioned in the judgment, and I'm going to simplify it for reason of time constraints. Actually, I didn't check how much time I have. I presume another 50 minutes, if I'm more or less correct? Okay, perfect. So the facts of the case as described in judgment are quite straightforward. There was a protest organized or coordinated as well by the de facto government in Gaza. And as a result, part of called the big return march, you have thousands and tens of thousands of Palestinians coming to the border to protest. Now, according to the judgment, you can divide them into 3 groups in general. The first one, all dressed in civilian clothing. The first one is a group of civilians coming to protest, to be part of the riot. The second group is more aggressive rioters, central rioters, who use cocktail Molotovs, throwing stones, burning tires, try to penetrate through the fence or remove the fence, etc. And the third group who are actually using firearms and explosive devices toward either the IDF or try to penetrate into Israel as a mission. And the judgment concluded that with regard to the first 2 groups, it's the law enforcement paradigm that applies. So you have to go through all the chain of other possibilities. You have the IDF had to use, for example, they did use in that context warning, tear gas, and other possibilities to disperse the mob. Of course, keep in mind that they don't actually enter into the Gazan territory in that case, because we're speaking about a border. And with regard to the third group, they were considered DPH, therefore it's part of the military operation paradigm, and they could use lethal force according to the rules of IHL. Now, 2 comments before I discuss a bit further. 2 comments I would like to make regard to this judgment, because there's 2 things that are quite interesting. The first is, and as I mentioned already before, Israel considers itself as a consistent or persistent objector to the applicability of human rights law in armed conflict. So in the submissions, the government argued that the law enforcement paradigm derived from IHL, not from human rights law. Now, interesting enough, 2 things happened. One, they explained that in many cases, in that specific incident, when speaking about the right to life in those events, actually it's very similar, if not identical, to the standards of human rights. So there was no, at the bottom line, in speaking about what Marcus mentioned, the bottom line actually from a practical perspective, they agreed that the standards are the same in that event, whether you use the law enforcement paradigm via IHL or directly from human rights law. And in that sense, the court also followed that approach. The second point, which I think is, could be interesting, is that the petitioners raised in the petitions mentioned some cases of the European Court of Human Rights. Now, Israel is not a member of the European Convention on Human Rights. It has no binding force. The jurisprudence of the court has no binding force. However, after stating that, the state and as well the judges themselves explained why the specific cases mentioned by the petitioners were not applicable for factual reasons in the case at hand. And I think that is interesting because it shows the importance of human rights. Even if you disagree of this applicability, the standards of human rights are sometimes used, even by states that say that it's not applicable, but still used because of the gravitas, because of the importance of actually checking what are the standards in human rights and see how you can adjust them to the situation, the military situation at hand. So I think that is quite interesting. I think it's a bit similar to what a lot of writings about the ICC, not only active complementarity, but also the passive complementarity. That even states that are not member of the ICC try to make sure they actually abide by the same standards and cover all the crimes in the Rome Statute. I think here it's a nice example of maybe I hope a phenomenon that will grow, that even if you're not bound by a specific regional convention, you could look at it and look and see whether you do abide by the same standards, and by, of course, using them within the situation at hand. Now, the issue of using interchangeably law enforcement paradigm and military operation paradigm, it's not at all obvious. I can imagine it's quite difficult, and the judge actually acknowledged that the soldier have a very difficult task. Because, and I'll give some examples, If you see a person throwing cocktail Molotov toward your direction, toward the fence, are you considering him as a violent rioter or someone DPH who actually tried to hurt you who is part of the hostilities? Now, if you're thinking about the right to life and the importance, then you want the soldier to presume that we're speaking first of all about the first case, just for the benefit of the doubt. In that sense, be on the safe side. If you don't have immediate threat, there's no reason to use lethal weapon in that case. And if you have immediate threat and you exhausted all the options, then you can shoot to the lower extremities and protect yourself according to a law enforcement paradigm. But it's getting more complicated than that. Imagine also a scenario where a person, protesters is using, and that was the case also in the Gaza border, they light up tires. Now you can say it's part of a protest, they're making smoke, but actually in some cases there was a suspicion they were using it as a smoke screen in order to allow other members of the same armed group to penetrate into, through the border and penetrate into the Israeli territory. So the question was, in that case, the soldier doesn't know the mens rea, doesn't know the intention of the person who actually light up the tires. You have to conclude from the situation. And if you look actually at, I like to look at the US Navy manual, who said that the combatant in the field have to make an honest assessment of whether the person is a civilian DPH, whether he directly participated in hostilities based on the attire, the behavior, the location, and other available information. Well, if you go look at the location, we're speaking about a border between two entities fighting for quite a long time. The attire, everybody is dressed as civilians, including people that are members of the armed group on purpose. And the behavior, well, that depends, it's open for interpretation. How do you see it? And that creates, I think, quite of a difficult job to the soldier in that sense. And if you use the Colombian example as mentioned, Marcos Soli, with, and I like it, the blue and the red card. Yeah, I can imagine, but I can imagine the soldier looking the blue, looking the red interchangeably every 5 minutes because it depends on the situation, it's very fluid. And the opposing side is using exactly that, using this exchange between the two regimes for their benefit, because they don't respect necessarily the rule of law, IHL nor human rights, it depends, and they will try to use it to their advantage, and you see it on the field, and sometimes it works. And this is the price of combating according to the different regimes. The situation can be, I think, even more complicated if you're looking from a different aspect. So if you're using law enforcement paradigm, the soldier not only can, but maybe even have a duty to use, for example, tear gas. But if among the same crowd, as I mentioned, is all the three groups are intermingled, basically using also tear gas in a military operation toward DPH. And that could be considered maybe as a war crime. And what happened, let's say if the same protest is in occupied territory and you're using other tools of law enforcement paradigm such as undercover, and you want basically you send a soldier or a police officer, it doesn't really matter, that he's undercover dressed as a civilian in order to arrest different violent rioters. But then he recognizes there is someone with a firearm who's going to shoot his colleague from the other side, but it's too far to arrest him or to stop him, and he actually, the soldier dressed as a civilian, fire toward that person. Does he also commit a war crime at that moment? Because he looks like a civilian. He doesn't respect the rules of IHL in that context, because then he changed completely to a different paradigm. And of course, this is an extreme situation, but it's something to think about how we translate it into the battlefield. And the point I'm trying to make with this example, is that the theory, the way the judges, Supreme Court, or other institution describe it is very, very clean, very neat, very, I'll say acoustic, it's very nicely designed and it seems very practical, but sometimes at the field, the way a soldier, 18, 20 years old, as was mentioned earlier today, have to decide which paradigms falls into is not that obvious, not that simple, even for lawyers sometimes. So I can imagine how difficult it will be on the ground for in real life situations. Another point I would like to discuss is actually from the other side of these situations is the duty to investigate. Now, it was mentioned before, both in human rights law, according to human rights law, and both in international humanitarian law, you have an obligation to investigate every death that resulted as a suspicion that was the result of illegal behavior. However, when dealing with use of lethal force, it's make a huge difference whether we are within human rights law regime or IHL regime. Under human rights law regime, if there's a death of a person as a result of the lethal force used by a state agent, then it triggers automatically an obligation to investigate. However, with IHL, the situation is not the same. First of all, the obligation, of course, there's an obligation in IHL to investigate war crimes, grave breaches, or any serious violation of IHL, or at least to examine other violation of IHL. But, and you can imagine crimes that automatically trigger, even according to IHL, an obligation to investigate. Looting, rape, torture, intentionally targeting civilians automatically will trigger a criminal investigation. There's no doubt about that. But not every death necessarily will trigger such investigation, even though the death was caused by a member of the armed forces. Because IHL, as was obviously discussed today, and we all know, I wouldn't say allow, but does not prohibit causing death at war. If it be a combatant, if it be a civilian who directly participated at that moment in the hostilities, and including innocent civilians in case it's part of a collateral damage that was not excessive to the military advantage anticipated while targeting exactly proportionality principle while attacking the legal military target. So in that case, you have first of all to examine whether there is a suspicion that the death resulted within the paradigm of IHL actually was the result of illegal behavior. So not every case, like in human rights law, will automatically trigger that requirement. And if we go back to the point I was making a moment ago, the example about law enforcement paradigm and shifting into military operation paradigm at the border, if there's a death on the other side, are we part of the law enforcement paradigm and you have to trigger investigation every single time? Or are we under the IHL paradigm where no, you have only cases where there's a suspicion that the person was targeted illegally? And that is also something we need to think about. My personal position in that you should have in every case of death we can, there's an argument, you can have at least a preliminary examination to see in which paradigm we're looking at in order to solve, and then decide according to that whether to open investigation if there is a real suspicion, whether there isn't a real suspicion according to IHL, or if you fall into law enforcement paradigm, if it's clear it was part of a right, then you have to open investigation in order to better know whether there was a misuse of the lethal force under that paradigm. Another point that is a bit difficult and is changing from the position of investigations in human rights law and in IHL is that in human rights law normally there's quite a high level of transparency in investigation. When a police officer fired toward a crowd, the discussion is much more public. Everybody is aware of the situation. When we're speaking about IHL, the investigation is not at all the same. States refuse, and it's quite understandable, to share the process of targeting, why the weapon was used, how they decided the person was a military target or not. If you look, for example, a recent comment I've been reading about the Dutch government in response to the issues discussion about ICCPR on Article 6, and they said, ICCPR nor IHL require to basically share the process of targeting. That would be also unrealistic considering the reality of hostilities. And I must admit, I tend to agree with that. It also might give the other side a lot of advantage in combat if they knew exactly how things are targeted and to know how to circumvent that and to make it even more difficult in the future to target the right people. So this is just some example I was trying to make within the time limit for a change. Some examples. I wanted to actually speak also about the issue of internment without trial, but I think it was quite nicely covered by my colleague to the panel. So thank you much for your attention and looking forward for discussions. Thank you.
Thank you. Thank you, Mr. Nick. Thank you that you discussed a special situation where IHL and human rights law could come into conflict. And now let me give the floor to Jean-Paul Laborde. Jean-Paul, you're welcome.
Okay, very good. When I was asked to participate to this meeting, no, there is nothing. When I was asked to participate to this meeting, I was thinking about something that you have not mentioned because I was not able to fulfill my obligations concerning the CV properly. Actually, I was during 4 years Assistant Secretary General in the UN at the Security Council for counterterrorism. And in the same time also, not in the same time, before I used to be also Deputy Secretary General of the International Association of Penal Law, which is much more in line with what we discussed, despite the fact that I had to deal with these cases in the Supreme Court also in France. The first thing I want to say is something concerning, since I am the last one to speak today, in this morning, something about this type of agreement on the fact there is complementarity between international humanitarian law and international human rights law. Actually, to be a little bit provocative, I would like to say that in my experience, especially in the experience of the Security Council of the United Nations, I saw exactly the opposite, unfortunately, but I speak by experience. Let's say among the P5, means the permanent members of the Security Council, depending on the situation, you can see that some of them insist on humanitarian law and some of them insist on human rights law. Say, no, it's not humanitarian law, it's human rights law, and then so on. So at the end, in terms of peace and security, which is overarching, framework for the conflicts now, because the conflicts are unfortunately very often decided at that level or looked after at that level, there is no agreement about this complementarity at the political level. At the academic level, I can concede that there is a complementarity, and since I'm professor also in Saint-Cyr, in the military academy, I always teach to my cadets that there is, of course, a complementarity, but then the questions start very often, and I am a little bit blocked by the experience that some of them have already in the field. So this is the first one. There is a huge debate in the Security Council about that. And especially to admit, even more often, that human rights are part of the overall framework of peace and security, rather than humanitarian law, which normally is well accepted. And why we have this debate? Because now, in addition to have the international conflict or not armed conflict, we have also to deal with what was my cup of tea every day, means terrorist organizations and terrorists. Even more difficult in this case. I'm sure that you remember, all of you remember, the debate that we had in France concerning concerning the members of Daesh, who were in the territory of Iraq and Syria, and on which, we had targeted killings by the aviation, by the Air Force. For some of them, means some professors, journalists, etc., human rights were not respected because it was exactly what you said, Professor, a targeted killing. And in the same time, that was interesting, many of them said he's not a combatant, but they claim to be combatants. So if you claim to be a combatant, you can be subject to a targeted killing. If you are not a combatant, but you are really combating your country or whatever country, are you still somebody subject to the, I would like to say, so-called peacetime law? That's already something which is a big debate, not only in the Security Council, but also for the trials which will come in the future. On the trials, I agree with also with Marco Sassoli that judges are not trained very much on humanitarian law. They are not, I have to confess, since I teach this subject, they are not even trained on international cooperation in criminal matters. But the inclination, the normal inclination for them, it is to apply human rights law, because this is something more familiar to them, very often. And I can see even in the court, when I was judge in the Cour de Cassation, I saw that very often. When they had a debate, when we had a debate on international humanitarian law and humanitarian rights law, they said, no, let's apply this one. Despite the fact that we could have found possibilities to apply the other one and give more, let's say, room and for the forces to do whatever they have to do. And then I would like also to quote some examples that I had in the field. One day I was in Mali, and we were just facing a very sad situation in which, Chadian soldiers were killed by a terrorist, combatant, most likely, but still, they wanted to arrest him according, which is rare for whatever kind of forces, according to human rights. Means that hold your hands, etc., and then they approach them for the palpation. Bam! 10 soldiers killed on the ground. Next time, of course, they didn't do the same. And what about the law enforcement, the gendarmerie in Cameroon, who spoke with me about Boko Haram people? They say we need to screen them, but since we have no material to screen them, we have to naked them, to put them naked, because otherwise we cannot know if they will make use of the explosive device or not. So that's a reality of what is when we can apply the first one, the second one, or its complementarity. And I would like to say that in this type of discussion, when you look after the cases in the human rights court, in the European Courts of Human Rights, you don't feel that they have the sense of this kind of reality. Also, there is something which has not been touched today. I will go briefly because I don't want to repeat what has been said. What has not been touched today is the principle of discretion for the application of the international humanitarian law. I was with your former president, Peter Maurer, last week in New York, and he said something that was very interesting. That was, of course, in the context of eventual cyber war, but war. They said, well, for applying, for applying international humanitarian law, very often we need discretion because we want to protect the life of the people and for the exchange of prisoners, for whatever type of work has to be done with the wounded person or to protect the civilians. We need to do that with a lot of discretion, which is absolutely not the case when you use, when we speak about human rights. This is something different. The concept is different. I don't say that it is better or bad or worse, but at the end of the day, you don't use the same ways. And of course, everybody refers to the cases of the European Court on Human Rights, especially the fact that they found a solution in saying that at the end of the day, Article 5, paragraph 1, could suffer an exception because of the fact that we are in a combat, and then we do not need to declare whatever type of declaration has to be made to the person who is in front of you. Imagine that you have a prisoner and you have to declare all the specificity of the Article 5, Paragraph 1. Means that you have the right to have this, you have the right not to answer, you have the right to this, you have the right to that. Yes, of course.
Article 5 doesn't have such a list. But...
Yes, it has. Right of liberty and security. Yeah. Right? That's the one. That's the one. So this is why I said for this right of security and liberty and security. Sorry, you have the right to have this type of declaration and the right to go before a judge, etc. So what I want to say is that, of course, when there is a situation in which the application of the European Convention on Human Rights cannot be done, it is interesting to see even that the European Court of Human Rights says that the Human Rights Convention applies and the rights applies within the what is the exact term? Within the context, I think something like that, of humanitarian law. So it means that they have not even abandoned the idea of human rights, you know, and they still say that human rights law applies within the context of lex specialis, not lex specialis. I think that these discussions about the application of the human rights also should refer to what you refer to, Colonel, the international civil and political rights of the UN, the Pacte des droits civils et politiques. That's interesting, but it means in this case we might have, which has been touched also by many of the participants, some discrepancies of application between, for example, the European countries which belongs to the Council of Europe and on which you will have the application of the convention, the European Convention of Human Rights, and the other ones for which you will have the application of the International Civil and Political Covenant. That's very, also, this discrepancy have to be touched. And this is why I really feel that for all of that reasons, whenever there is an application of international humanitarian law in an armed conflict, in an armed conflict, in whatever type of, and it is even more difficult, terrorist situation that we might have when there is a situation of combatants according to the international humanitarian law, this law should, of course, prevail. And now, the last point I want to make is concerning the issue of extraterritoriality. This is interesting, and that was the last comment I wanted to make. The issue of extraterritoriality is very interesting, according to what the European Convention, European Court of Human Rights has said. We will go probably to the second panel this afternoon on that issue. The issue of extraterritoriality and of the forces which occupied a territory is deriving from the international law, fine. And I don't know how, really, it can be applied by the European Court of Human Rights, but because normally this court applies the rules of the conventions and the provisions of the conventions between states and citizens of the country. Now we apply these rules outside of the territory between, of course, states and what? Citizens of what country? Of all countries outside of. So where is the link here between the European Convention of Human Rights according to the jurisdiction of the court and exactly the terms of the treaty? Maybe there is a confusion here, and this is why I come back to what I said concerning the inclination of the judges to really look after human rights first, is because they want, I mean, it is clear that the court wants, of course, to get jurisdiction in order to declare some responsibility of the state. Because possibly the responsibility of the state is there, but it doesn't mean that jurisdiction for the court is also there. That's what I wanted to say. And on that, I would like to say thank you very much for having invited me, and I hope that with all these questions we can find a way to find also solutions. Thank you.
Mr. Laborde, thank you very much for your report, and dear experts, thank you very much for such representative picture as going on regarding IHL and human rights law. And now it comes for questions, please. Do you need the microphone? Do not to hesitate any question. Do not hesitate any questions for our experts. Where is the mic? Puff. Puff.
Thank you very much. Firstly, a factual question. Adi, what was the name of the case at the Supreme Court? Yeah, but is there in the name of the case? Like targeted killings or? Okay. Secondly, a factual, thank you. So it's 3003/2018. Secondly, Jean-Paul Marco, I think that you were talking about two different conventions and two different Articles 5. Correct? So Jean-Paul, you were referring to European Court of Human Rights and respectively to the right to be informed in the language that the person being arrested understands about rights, circumstances, etc., etc., etc. Just a quick follow-up to experiences shared by the two retired, one reserve militaries, and it's not a scenario. And Adi, you may have heard this story from me before, about a student that I had who was a quite distinguished member of the airborne forces, and he was the only one who came to my class wearing his uniform, while I suspected that there were quite a few other members of the military or other services. And I gave him an assignment to deliver a paper for the next class that would deal with, let's say, perception by a commander of rules of IHL that he was supposed to apply in combat. He gave an excellent paper, very well structured, very well organized, excellent argument. There were many questions, and after the audience exhausted their questions, I was the one who still pressed him. And ultimately, this big, strong, and as it turned out, highly decorated major at the time, he said, "Professor, if I follow the rules to that tiny detail, I will lose my man and fail my mission." Now, once I gave this, cited this example at one of the roundtables hosted by the Institute of International Humanitarian Law, being a moderator of a panel which included one distinguished member of the staff of ICLRC, and the person was distinguished both as an operative and as an academic. And that person went back to me adamantly, no, that should not be the case. Rules must be applied no matter what. What would be a comment on that? Anyone? The militaries would be probably most proper to carry that, but I don't know if you want to collect more questions.
On the last point, I quite frequently provided advice to special forces units in the U.S. military. I was the U.S. Army Special Operations Command Staff Judge Advocate, and many years before that as young captain, the 5th Special Forces Group legal advisor. And I quite frequently got comments like that from the operators. They would say, well, I would much rather be judged by 12 than carried by 6. And my response to that was, I'm also the group prosecutor, so I'll work on the first part, the judgment by 12, and you'll have to realize that when you decide to do something that's illegal, that it never stays secret, that it always comes out at some point in time. I mean, we just got the ICLRC hijacker 30 years later. That we were talking last night at dinner about the number of people from World War II that have still been prosecuted these many years later. So I think that's a valid perspective from those folks, but they have to realize that the consequence of them making that choice in that instant, it may be their own death, but it also may be their own prosecution later on. I wanted to add too, there's a UN commission on the Gaza fence incident that there's also an Israeli Supreme Court opinion on, that the Israeli Supreme Court opinion preceded the commission report that came out in March of this year. Yeah.
Any more comments?
Just to answer your point, I think we have to distinguish 2 levels. One level is misunderstanding the law. Most of the time, such comments, in my view, misunderstand the law because they think the law requires something which is unrealistic, while the law was made by military people, in the presence of military people. And therefore, they thought when they made the law that this is realistic and it can work. And obviously, as always with lawyers, when we apply the code civil to selling a computer program, we apply it and it works, but we have to adapt it to the special situation. Like when it's a special operation, then we have to adapt our interpretation to this environment. But obviously there is a line where I agree with my former ICLRC colleague. I mean, if this means torture, then no, it's prohibited. And there I remember a French colonel who was once confronted to a class, and the class said, yes, but I mean, it's obvious that if this is the person who has the information, I will get this information. And then the colonel said, look, I think you misunderstood your task, because imagine how you ruin your country if then it comes out in the media that a French military tortured them. Yeah. So, and your task is to defend your country, but you ruin your country. And you must even be ready to die for your country, then you must be ready not to torture for your country, even if it looks as if it is the most efficient way to get the information and so on. And I think he convinced everyone in the room that this was a misconception. But indeed, for the rules, we have to make sure, by the way, and Cordula Dröge made an important point I forgot, the rules must be realistic, and the rules for non-international armed conflicts must be realistic for both states and non-state actors. And here we have to be conscious that the rules, states produce the law and therefore make sure that it is realistic for them, while for the non-state actors, obviously we have to make a special effort to make sure that the rules are not unrealistic, because unrealistic rules don't protect anyone.
Yeah, but in this case, this is really international humanitarian law, I think. It is quite clear. But you respect also human rights in doing that. That's because you don't torture somebody, but it's already in the international humanitarian law. So you don't have to do anything else. And this is a question I have very often about torture by the cadets, and I say exactly the same that Marco Sassoli said. It means if you want to ruin the reputation of your country, do that. And look what after all these bad behaviors in the prisons in Iraq. And, the U.S. Army was really, absolutely. I would like to say sentenced before even having been sentenced. This is normal, and the people at the end were sentenced anyway. So you cannot do something like that. I want also to refer to a case which is exactly exactly the opposite. You remember the last operation that the special forces, French special forces, conducted in Benin, and 2 French special forces members were killed. You know what they did? They, in order not to kill the people who possibly had nothing to do with, the deprivation of liberty of the hostages, they went into the tent without any arm, without any weapon, the first ones. Imagine that, okay, they were killed. And even the family said that was their duty, they did the things rightly. Imagine they start to shoot. First of all, what about the hostages? Second, you don't know if the people inside are armed or not, so they decided to go like that and even to risk their life. But at the end of the day, in such an operation, you can see that the people, even they were dead, poor people, they did the things in the right way.
Yes, you can.
Just a quick comment, general comment, and then I want to mention actually an example that I think something which we all should keep in mind. My first comment is that soldiers, in general, also should remember that, with all respect to lawyers and judges, at the end of the day, we do not replace the decision-making process of the professional, of the person who actually taking a decision. And in judgments, you can see that in judgment throughout, dating already from after the judgment of the Second World War, and even nowadays, we can see also in the Kunduz case, when the German prosecutor stated also in the same aspect that you do not replace, you give the leeway to the professional in the decision-making, and it's only in the extreme cases when it's obvious there was a mistake, is there when the legal proceedings are starting. You have to have some kind of a boundaries also to respect. It's very easy to take 3 days to analyze an incident that took 5 minutes on the ground in that sense. So with this some kind of respect from I think both lawyers and judges to to the army in general. Well, recognizing, of course, in case of torture, there's not even discussion. That's, of course, it's illegal, and that is straightforward. But I'd like to mention a case, as we were talking, I remembered a case where there was 3 armed group, 3 terrorists hiding in a house. And the army tried to convince them to get out of the house. And they fired at them, didn't work, they shot them to come out, they refused to do so, and so they emptied the house itself. They had sharing the same wall with another building. So the army evacuated the other building in order to bring Air Force to destroy the building where the 3 terrorists was staying. And they refused, of course, to surrender. Now, the neighbor, realized they're going to destroy that house, which means going to also hurt, damage to a certain extent his house. So we asked the commander at the field, let me talk to them. Being also Palestinian, let me talk to them, try to convince them to surrender. And the commander thought he was doing the right thing, said, okay, you can go ahead. And actually the person went 3 times, tried to convince them to surrender. They refused to surrender, and the army destroyed the house, and it caused damage to the house adjacent. Now, the commander had a problem because technically he put civilians in harm's way. He was no right, according to the law, to use, or you can use a human shield, or to use them as an emissary in that sense. That is against international, that is against even the jurisprudence of the Supreme Court, saying you cannot use civilians in that situations because of the danger of a slippery slope that you might use them more and more, and etc. And there was a problem with that. And there was no criminal proceeding, but there was administrative proceedings against him. And I think in that sense, maybe something we should, I think, now think out loud, to be honest, copying from maybe the German defense law, of defenses and criminal law, that you may have to think about justificatory defenses and defenses where you say, okay, what you did was wrong, but we don't blame you for that. Because there is issue international, it was complicated, you're trying to do what morally is right, but we want to know the other soldier, we know the population to know that this was not right. So we don't go into criminal proceedings, but it's some kind of reprimand, some kind of statement flagging, do not do that again, this is problematic. It's in a gray zone, but it's problematic, you don't go that direction. And to other cases, when obviously there is actually a crime committed, then you go through the criminal proceedings. I think maybe that will give a bit more confidence also soldiers saying, and I understand the statement of saying we don't want to be carried, I prefer to be judged than dead, to leave some leeway in the sense you have some examination, some part of examination that you actually can learn from it. You learn as part of an experience to learn, and it will be flagged as a problem when it's kind of a gray zone. But if you need 3 days, 10 lawyers, and 5 judges to decide if the act was actually legal or not, then we need to understand that something, from our perspective, maybe putting the soldier in a position which is more difficult than they can actually bear. Thank you.
Thank you. Any more questions? Judge Mohammed, thank you very much for organizing the discussion. Okay. The questions of how to distinguish situation where the IHL should be applied or human rights should be applied, or both. How the rules of these bodies, 2 bodies of law, should be applied together, and finally, how to resolve conflicts that raise are still open. But today's discussion, I think, shed light on at least some issues. I was sure before the last discussion, now I think that the practice of international humanitarian bodies and maybe international tribunals would fuel and encourage the further discussion concerning the concerning the interrelation between IHL and human rights law. And I would like to thank you very much for our expert and for participants for your involvement. Thank you very much, and bon appetit.